Brooke Astor was dying. Alzheimer's had taken her mind. Her own son, Anthony Marshall, had her power of attorney, and he used it to steal from her. The document that proves it is a settlement agreement, signed March 28, 2012, in a Westchester County courtroom. Brooke Astor had been dead for nearly 5 years by then. She had given away close to $200 million in her lifetime, and New York had called her, without irony, its First Lady. The document that finally closed her affairs was not signed by her. It was signed by lawyers, on behalf of charities, over the objections of the one person who should have protected her, her only child. One clause: Anthony Marshall would receive $14.5 million from an estate her 2002 will had set him to inherit at nearly $70 million. Less than half. And even that wasn't his to keep. This document ended the negotiation. But every dollar in it traces back to a theft that started while she was still alive, still breathing, still trusting him, and still completely unable to stop him. Her name at birth was Roberta Brooke Russell, born in 1902 in Portsmouth, New Hampshire, to a Marine Corps general and a mother who had been raised in the rigid, exacting etiquette of old American gentility. Her childhood was itinerant. Military postings carried the family from Washington to China and back. But the lesson underneath every posting was constant. A woman's value lay in her composure, her taste, her ability to make any room she entered feel correct. She was taught to charm. She was taught to listen. She was not, in any meaningful sense, taught to earn. By the time she reached adolescence, she had already absorbed the central rule of her class and era: a woman's security was assembled, not built. It arrived through marriage, through inheritance, through the careful management of relationships with men who held the actual capital. Nothing in her upbringing prepared her for an alternative. At 17, she brought youth, a striking presence, an unimpeachable family name, and a fluency in the unwritten rules of high society that few of her peers could match. What she did not bring was money of her own, or any legal claim to the resources that would govern the rest of her life. In 1919, a young woman's social capital, her name, her bearing, her marriageability, was real currency. But it was currency that, the moment she married, transferred control to someone else. She married John Dryden Cuser that year, in a wedding that placed her inside one of New Jersey's wealthiest families. He was the grandson of a United States senator, heir to a fortune built on land and political connection. She was 18 years old, and she had just signed, without quite understanding it as a contract, the first term of her adult life, her independence, traded for security she did not yet control. No one at that wedding would have called it a negotiation. It was described, the way these arrangements always were, as a romance, a happy union of two good families. But strip away the language society used to dress the transaction, and the terms were plain. She brought youth and reputation to the table. He brought capital. And in 1919, capital wrote the contract. John Dryden Cuser brought money, more than she had ever had access to. He brought a family name that opened doors hers alone could not. And he brought, by her own account decades later, violence. She was 6 months pregnant with their only child when he broke her jaw during a marital argument. She called those years, without softening the language, the worst of her life. He drank. He was unfaithful, openly enough that it became part of the social record around their marriage. A year into it, he began, in her words, to embarrass her in public, and eventually told her plainly that he no longer loved her and that their marriage had failed. Phrasing that placed the failure between them equally, as though it were a joint debt, rather than naming what it actually was, a man's cruelty, presented back to her as a shared disappointment. What he controlled that she could not access was straightforward and total. The money was his, structured through trusts and family holdings she had no claim to outside the marriage. The name was his, useful to her only as long as she remained attached to it. And the social cost of leaving was a weapon he never had to raise his voice to use. A divorced woman in 1920s America carried a permanent mark that a divorced man simply did not. He understood this, and he let the threat of that mark do the negotiating for him. He never had to ask her to stay. The world around her did the asking instead. This is a term that recurs so often in stories like hers that it is easy to stop noticing it. The abuser does not always have to enforce the terms himself. Sometimes the surrounding world, its judgments, its gossip, its narrower tolerance for a woman's mistakes than a man's, does the enforcing for him for free, indefinitely. It is the cheapest leverage there is because no one ever has to write it down. She filed for divorce on February 15, 1930, in Reno, Nevada, the fastest legal exit available to a woman of her means and era, a 6-week residency requirement standing between her and a decree that almost anywhere else in the country would have taken years and required proof of fault she might not have been able to produce to a court's satisfaction. To get that exit, she gave up the marriage's financial protection, its social architecture, and any future claim to the considerable user fortune beyond what was negotiated at the close. What she received in return was her son, Anthony, then 8 years old, and her freedom from a man who had broken her jaw while she carried that same son inside her. She did not receive a fortune. She did not receive vindication in any public sense. Divorce in 1930 was whispered about, not celebrated, even when the husband's conduct was a documented cause. She received an exit, purchased at the price of her reputation, and she was 28 years old when she walked through it, with no clear plan for what would replace the security she had just surrendered. Notice the shape of this first term, because it will recur. She traded something permanent, her marriage, her place inside a wealthy family, for something temporary, relief. Not security. Not vindication. Just an end to one specific danger, with no guarantee against the next one. The divorce was finalized later in 1930. The settlement, measured against the scale of the family she had married into, was modest, enough to live on, not enough to be called wealthy in the company she had spent the last decade keeping. She did not walk away rich. She walked away independent only in the narrowest legal sense, unmarried, undefended by a husband's name, and solely responsible for raising a young son who now carried a surname disconnected from the household that had once surrounded him. For a woman raised to believe security was something assembled by marriage, this was a frightening kind of independence, the kind with no safety net beneath it. What followed was unusual for a woman of her background. She went to work. She wrote. She took a position as a features editor, first at House and Barden, learning, out of necessity, not ambition, the actual machinery behind the taste and presentation she had been raised to perform but never to produce. The first negotiation of her adult life had cost her a marriage and the security it carried. It had also, almost as a byproduct, handed her a set of professional skills no one had ever planned for her to need. How to build something, manage a budget, meet a deadline, function without a husband standing between her and the world's demands. She would later say she was grateful, in hindsight, for those years, not because they were easy, but because they were hers, in a way nothing before them had been. In 1932 she married again, to Charles Henry Buddy Marshall, a man she would later describe as a great love match, the first marriage in her life entered, by every account, on her own terms rather than her family's or society's. There is no documented cruelty in this marriage, no broken bones, no public humiliation. But there was a new and different kind of vulnerability waiting inside it. By the mid-1940s, Buddy's financial fortunes had turned, and the woman who had once relied entirely on a husband's money found herself, again, working to help keep a household afloat. This time the negotiation she faced was not about escaping a man. It was about staying solvent inside a marriage that could no longer guarantee the security marriage was supposed to provide in the first place. She returned to magazine work. She decorated apartments, including, notably, her own residence at 1 Gracie Square, worked on with the prominent decorator Ruby Ross Wood and her associate Billy Baldwin. She built, quietly and out of necessity, the exact social and aesthetic fluency that would later make her indispensable to New York's wealthiest cultural institutions, without yet knowing that this fluency, more than any marriage, would eventually become the foundation of everything she was remembered for. It is worth pausing here, because this is the marriage history tends to flatten into a single soft word, happy. It was happier than the first, certainly. But happy did nothing to protect her from the same underlying vulnerability that had shaped her entire adult life. Her financial footing still depended, almost entirely, on a man's continued solvency, continued health, continued presence at the table. Buddy Marshall died in 1952. 11 months later, in October 1953, she married a third and final time, William Vincent Astor, chairman of the board of Newsweek magazine, heir to one of the great American fortunes, the last rich male descendant of the Astor name. This marriage gave her, finally, at the age of 51, the financial security the first two could not offer. But it carried its own cost, one rarely examined in the polished retrospectives of her life. By the time it began, she had spent more than 3 decades of her adult life requiring a husband's name and a husband's money to secure her own footing in the world. Whatever capability she possessed, and the record shows she possessed a great deal, none of it had yet translated into a fortune that was unambiguously hers, built on her own labor, answerable to no man's mortality or temperament. Vincent Astor died in 1959, after only 6 years of marriage. She was 57 years old. For the first time in her life, the money was, on paper, hers to direct. The pattern she could not yet fully name, though she would later come close to naming it in her own writing. Every time she had gained real ground in her life, it had come through the death or the failure of a man. Nothing had simply been handed to her, free and clear, as a matter of right. Even the freedom that finally came to her in 1959 arrived as a widow's freedom, granted, not earned, structured by a will she had not written, governed by a power of appointment that Vincent's own lawyers had drafted. Look closely at that last detail because it matters more than it seems to. Even at the moment of her greatest independence, the instrument that delivered it was still someone else's. She had not written the will. She had not drafted the trust. She had simply, finally, outlived the man whose document it was. Real control she had built from nothing, on terms she had set herself, was still 3 years away. Across 4 decades, through one cruel husband, one financially unstable husband, and one husband who finally delivered security only by dying, there was a single thing Brooke Astor kept trying to secure, in different forms, at every table she ever sat down to: control of her own resources, usable on her own terms, without needing a man's permission, presence, or survival to make that control real. After 1959, she finally found a version of it. She took the helm of the Vincent Astor Foundation and ran it for nearly 4 decades, personally directing close to $200 million toward New York's institutions, the Bronx Zoo, the New York Public Library, low-income housing projects in the South Bronx and Harlem, the restoration of the city's public playgrounds. She visited the projects she funded in person, often unannounced, climbing tenement stairs in designer suits to see for herself whether the money was reaching the people it was meant for, in a way most major philanthropists of her era did not bother to do. She read every grant request herself. She rejected ones she thought were vague or self-serving. For the first time in her life, she negotiated as a principal at the table, not as a dependent seated beside one. The terms, finally, were hers to set, and the city responded by calling her, with real affection, its First Lady, a title earned, unlike every position she had held before it, through her own labor rather than a husband's name. It would not last. The same control she had spent 40 years building, dollar by dollar, decision by decision, would be taken from her in the final decade of her life, not by a husband this time, but by her own son, the boy she had carried out of a marriage that broke her jaw, the one person whose loyalty she had never once had reason to doubt. If you've followed this story this far, you already understand the shape these documents take, how a life of hard-won control can be quietly dismantled by exactly the person trusted to protect it. There will be more terms ahead, and they get harder to read. If this kind of history, the quiet machinery behind names everyone thinks they already know, is something you want more of, the channel covers stories exactly like this one. Subscribing costs nothing, and it tells us there's an audience for the parts of these lives the official record tends to leave out. By the late 1990s, Brooke Astor was in her mid-90s, still attending galas, still photographed at openings, still presented to the public as the indomitable Grand Dame of New York philanthropy. Behind that public image, she had been diagnosed with Alzheimer's disease. The control she had spent a lifetime assembling required, by its very nature, a mind capable of exercising it, and that mind was failing, gradually at first, then with accelerating speed. This was the structural trap at the center of everything that followed, and it was not one any single villain engineered alone from nothing, though one man would come to exploit it with calculation. As her capacity diminished, the legal instruments she had once wielded as a fully competent principal, her powers of attorney, her testamentary documents, the checking accounts that bore her name, became instruments that could be wielded in her name by someone else, with her signature but without her understanding. She had granted her son, Anthony Marshall, powers of attorney in 1978, in 1980, in 2000, and again in January 2004, along with a healthcare proxy in 2001. Each one, at the moment it was signed, was a reasonable estate planning decision made by a competent woman providing for her own future. Each one became, as her dementia progressed, a tool that required no further consent from her at all to use. The thing she had spent her entire adult life trying to secure, autonomous control of her own resources, could not, in the end, be protected by any document, because the documents themselves were precisely the mechanism through which that control could be quietly transferred away from her. Not stolen in a single dramatic act, but signed away, instrument, by the person she trusted most at a point when she no longer had the capacity to notice what she was losing. This is the cruelest mechanism in the entire record. It was never a stranger reaching into her accounts. It was the legal architecture of trust itself, built for her protection, decades earlier, by a woman who never imagined the hand holding the pen would one day belong to the only person she had no reason to fear. By 2003, court records would later show Mrs. Astor was experiencing dozens of documented instances of confusion and disorientation each month, and nearly as many instances of paranoia, the two often arriving together in the late afternoon and evening hours, a pattern her caregivers came to recognize and dread. She would ask, repeatedly, where she was, despite having lived in the same Park Avenue apartment for years. She would accuse staff she had known for a decade of stealing from her, an accusation that, in a bleak irony the court record would later make plain, was eventually true, just not against the people she suspected. In December of that year, her longtime attorney supervised the execution of a codicil to her existing will, the first of three that would follow within the next 15 months. That December document, later referred to in court as the first and final codicil, gave Marshall the right to appoint 49% of the assets of a major trust to charities of his own choosing rather than hers. Her own attorney, asked years later under oath why he had labeled the document final, could not recall. He testified he had never used that phrasing before, and the timing suggests it was meant to close the door on what would, instead, become the very beginning of the worst of it. This was the moment the negotiation of her life reversed direction. For her entire adult life, the terms at every table had been about what she could acquire, build, or protect for herself or for the causes she chose. Now, for the first time, the terms were about what could be taken from her without her fully understanding that she was giving anything away at all. She was no longer negotiating for more. She was, without knowing it, now negotiating simply to keep what she already had. And she had no idea the negotiation had even started. That is the detail that should stop you. Every earlier table in her life, however unfair, was a table she at least understood she was sitting at. This one, she didn't even know existed. By early 2004, she could no longer meaningfully negotiate for autonomy. Her capacity had already been substantially compromised by the time the most damaging codicils were drafted. What was negotiated instead, on her behalf and increasingly without her, was simply speed, how quickly a document could be placed in front of her and signed before anyone outside her son's circle could intervene. On January 12, 2004, a lawyer she had met for the first time only 20 minutes earlier presented her with a second codicil. It eliminated the charitable remainder trust that would have funneled the bulk of her residuary estate, roughly $30 million, to the charities she had spent decades supporting, and gave that money directly and outright to her son instead. She signed it at the close of that 20-minute meeting, with no independent counsel present to explain what the document changed or why. 6 weeks later, on March 3, 2004, a third codicil appeared bearing her signature, diverting still more money away from her favored institutions, including raising the legal fees and compensation owed to Morrissey himself, the man who had helped engineer the entire sequence. A forensic handwriting examiner, hired later by her court-appointed attorney, testified in his report that by that date the deterioration in her ability to write her own name made it physically impossible for her to have produced the signature on that document. It had been forged. Morrissey would later be convicted specifically for that act. What she negotiated for by this point in the story was not a term at all. These were not her terms, freely chosen. They were terms presented to her in rapid succession, and in at least one documented instance manufactured outright in her name, while the structure around her ensured no independent party was present at the table to ask whether she understood a single word of what she was being asked to sign. In 2005, with his mother's power of attorney now fully under his control, Marshall granted himself a retroactive pay raise from her funds exceeding $1 million. Compensation for his role managing her affairs he was, by this point, managing almost entirely for his own benefit. He used her money to purchase a 55-foot yacht. He paid the yacht captain's wages from her accounts. He used her funds to cover expenses tied to property his wife owned in Maine, and to pay the salary of a woman nominally employed as his mother's social secretary, who in practice worked for his own theatrical production company, a venture that had never turned a profit on its own merits. By this point, what remained on her side of the table was almost nothing in any practical sense, not because her underlying fortune was small, but because she no longer possessed any capacity to monitor, question, or refuse what was being drawn from accounts that were, in name only, still hers. Members of her household staff began to notice the pattern, even when they lacked the standing to stop it. One employee in her business office would later allege that Marshall had diverted close to $1 million from his ailing mother's personal checking accounts into financing his theatrical productions. Through a spokesman, Marshall maintained that his mother had known of these investments and approved them. By every documented medical account from that period, she was, by 2005, incapable of approving anything with the informed understanding the word approval requires. Nurses who cared for her in those years kept private diaries, later compiled and published accounts of her final years, records describing a house cold in winter for want of heating she could afford many times over, a torn and stained couch left unreplaced in her own sitting room, the same nightgown worn for days at a stretch, prescriptions and doctors' visits quietly reduced even as money moved freely in the opposite direction, toward accounts that were not hers to spend from. These were not the conditions of a woman without means. They were the conditions of a woman whose means had been redirected, clause by clause, away from her own care and toward someone else's comfort. A 103-year-old woman with a fortune in the hundreds of millions of dollars. The same torn couch left unrepaired week after week, while her son's yacht sat docked somewhere with its captain paid from her checking account. There is no softer way to say that, and the script will not try to find one. In July 2006, Marshall's own son, Brooke Astor's grandson, Philip Marshall, filed a petition in New York court to remove his father as her legal guardian, asking the court to appoint Annette de la Renta in his place. The petition alleged that Anthony Marshall had allowed his elderly, ailing mother to live in conditions far below anything her fortune could comfortably provide. That torn couch, stained with urine from a dog she could no longer properly care for, medication scaled back, doctors' visits curtailed, her favorite child a Hassam painting sold in 2002 without her knowledge or informed consent, the proceeds unaccounted for. Affidavits supporting the petition arrived from Annette de la Renta, from Henry Kissinger, from David Rockefeller, people who had known Brooke Astor across decades of her public life and who now stated, under oath, that the woman described in the petition bore no resemblance to the woman they believed was being properly cared for. The court responded within a day, appointing Annette de la Renta as temporary guardian of her person and J.P. Morgan Chase as temporary guardian of her property and finances, with authority to direct her medical care, her housing, and her relocation to her own home in Briarcliff Manor, away from the conditions described in the petition. Court filings noted that Mrs. Astor's total assets exceeded $120 million at the time, a fortune large enough that none of the deprivations alleged in the petition could be explained by any genuine shortage of funds. The guardianship proceeding settled on October 13, 2006, 6 days before it was scheduled to go to trial, after weeks of attorneys working through the terms late into the night. Under that settlement, Marshall and his wife, Charlene, returned more than $11 million in cash, jewelry, and artwork to Mrs. Astor's estate, and pledged over $10 million in collateral against any future claims that might be brought on her behalf. Marshall, his wife, and two of the attorneys involved in drafting the disputed codicils, Francis Morrissey and Henry Christensen, agreed to renounce any right to serve as a fiduciary under her will, her codicils, or any other testamentary document she had signed. This was the final negotiation Brooke Astor would ever be present for, in any sense that mattered. She was alive when it was signed. She did not understand its terms, could not have understood them, and was not capable of weighing what had been returned against what had already been spent, sold, or diverted in the years before anyone outside her own household had noticed. She died less than a year later, on August 13, 2007, at the age of 105, of pneumonia, in the Briarcliff Manor home the settlement had returned her to. Read that sentence again. The home she died in was the home the courts had to fight to give back to her, a home that, for years, had belonged to her on paper while someone else decided how she lived inside it. After her death came the criminal trial. Anthony Marshall and Francis Morrissey were indicted in November 2007, the indictments stemming from a grand jury investigation into the mishandling of Astor's money and the questionable signature on that third codicil. The trial began in March 2009 and ran 6 months, one of the longest and most closely watched white-collar trials New York had seen in years, before a jury reached its verdict that October. More than 80,000 pages of documents had been produced in discovery across the related civil and criminal proceedings. Mrs. Astor's own family members, doctors, nurses, caretakers, former staff, and financial advisors were called to testify to what they had witnessed in her final years. The jury convicted Marshall on 14 of 16 counts, including first- and second-degree grand larceny for, among other acts, taking an unauthorized $2 million commission on the sale of his mother's favorite painting, the Childahasam beach scene she had specifically asked to keep, and for the scheme that produced the second and third codicils while she lacked the capacity to consent to either. His co-defendant, attorney Francis Morrissey, was convicted of forgery, scheming to defraud, and conspiracy for his role in producing the third codicil and its forged signature. He was later disbarred. Marshall was sentenced to 1 to 3 years in state prison. Even after the conviction, the estate itself remained legally unsettled for years more, tangled among more than a dozen New York institutions with claims against it: the Metropolitan Museum of Art, Carnegie Hall, the New York Public Library, Rockefeller University, the United Nations, all owed bequests that depended entirely on which of the 8 wills and codicils Brooke Astor had signed since 1997 were ultimately found legally valid, and which had been procured through fraud or undue influence during the years her capacity was already failing. On March 28, 2012, after 2.5 years of negotiation among the Attorney General's office, the charities, and Marshall's attorneys, a global settlement was finally accepted by the presiding judge. It restored her original 2002 will as the governing document of her estate and voided every codicil signed afterward. The very documents procured during the months her medical records showed her drowning in confusion and paranoia. Under that 2002 will, before any of the disputed codicils, Marshall would have inherited close to $70 million outright. Under the 2012 settlement, he received $14.5 million instead. That number alone understates what the theft actually cost him. $11,600,000 in legal judgments stood against him by then, debts run up defending himself from the consequences of his own conduct. $12,300,000 more was owed in restitution, paid directly to the Manhattan District Attorney's Office, the very office that had spent years and a small fortune proving, to a jury of his peers, that he had stolen from the woman who raised him. Subtract those figures from his inheritance and what's left is under $3 million. A man who could have walked away with $70 million instead kept less than $3 and carried a 1 to 3 year prison sentence into the bargain. Each of her grandsons received $1 million. The great bulk of a fortune once valued near $200 million passed instead to the charities she had spent her life building and supporting: educational funds, Central Park, the city's playgrounds, and a new philanthropic fund established and endowed in her own name, so that the giving she had spent 4 decades directing herself could continue without her. He was 87 years old when the settlement closed, his prison sentence still pending against him through a slow-moving appeal. He had been, in the plain language of the court record, disgraced, convicted, and stripped of all but a fraction of what his mother had once fully intended for him, not by strangers, not by the state acting against his interests, but by his own hand, through his own documented theft, from his own mother, while she was dying and no longer able to object. There is one clause buried inside the criminal court's later ruling on appeal that says more, in fewer words, than the rest of this record combined. It addresses the jury's finding concerning the period from September 2003 through March 2004, the very months in which the most damaging codicils were drafted, presented, signed, and in one case forged. The finding states that the defendants engaged in a scheme to defraud Mrs. Astor by changing her will at a time when they knew her physical and mental condition precluded her from having the capacity to agree to any such changes. They knew, not suspected, not failed to notice, the way a distracted son might miss the signs of his mother's decline. The court's own language is new, a finding that the men closest to her, including her own son, understood exactly what they were taking advantage of, and proceeded anyway. Every clause before this one in her story can be read, generously, as the slow accumulation of disadvantage that befalls any woman who spends a life depending on the men around her. This last clause cannot. It is not a record of what was lost to circumstance. It is a record of what was taken, on purpose, by someone who knew precisely what he was doing, from a woman who, by then, could no longer ask him to stop. She gave away nearly $200 million across her lifetime to causes she chose herself, with a discipline almost no philanthropist of her era could match. And in the end, the largest single transfer of her fortune was not one she authorized at all. It was one written into a document while she sat in a room, confused, unable to write her own name, signed by a man who had called her mother for 85 years and knew, the court's word, not this one, exactly what he was doing to her when he did it.